The exploding package that changed law forever. Picture this. It's 1924. Helen Palsgraf is waiting for a train with her daughters when chaos breaks out. Two men are rushing to catch a different train that's already moving. Railroad employees try to help one guy jump aboard, but in the process, they knock a package out of his hands. The package contained fireworks wrapped in newspaper, but nobody knew this. The package hit the tracks, explode, and the shock waves knock over a huge coin-operated scale 25 to 30 feet away. That scale crushes Mrs. Palsgraf. She sues the railroad for $6,000, arguing their employees were negligent in helping the man aboard. This is all about causation. Specifically, was the railroad's act a substantial factor in bringing about the injury? And here's where it gets legally fascinating. The trial court said yes, she wins. The explosion would not have happened without the employee's actions. But for their help, no explosion, no falling scale, no injury. That's factual causation, clear as day. But then legendary judge Benjamin Cardozo stepped in and overturned the verdict. He created a new test, legal causation. Just because you factually caused something doesn't mean you're legally responsible for it. Cardozo's reasoning was revolutionary. The railroad employees had no duty to protect Palsgraf because injury to her was not foreseeable. They were helping a man with what looked like a harmless package. How can they predict it would contain fireworks that would explode and knock over a scale 30 feet away? But Justice Andrews wrote an epic dissent that still gets quoted today. He argued that if you act negligently, you're responsible for all the consequences, no matter how bizarre. He said the question isn't foreseeability, it's proximate cause. Was there an unbroken chain of events? Both judges agreed the explosion was the direct cause of her injuries. The fight was over how much responsibility you should have for unforeseeable consequences. This case literally created modern causation law. Cardozo's approach won. You need both factual causation, the but-for test, and legal causation, foreseeability. You can't be held liable for every random consequence of your actions, no matter how bizarre the chain of events. The case is taught to every law student because it perfectly illustrates the difference between did you cause it and should you pay for it.